Hello everyone, and the topic that we have been discussing from a few videos, that is administrative law. And in this video, I will discuss types of administrative action. Okay, so what is the meaning of administrative action? First, understand this. So whatever the act that an administrative body does, performs, exercises, that is known as administrative actions. So based on the nature of that act or action, those actions are categorized into four forms as administrative legislative action, means if it is making the laws, bylaws or anything or any such provisions, that is known as administrative legislative action. Okay, it is legislative action, but it is done by the administrative body, so it is administrative legislative action. Secondly, quasi-judicial action or administrative adjudicatory action. What does it mean? That when an administrative body plays the role of judiciary, decides the cases by resolving the disputes, okay, that is known as quasi-judicial, since it is being done by an administrative body, not by a judiciary. So it is not judiciary, rather quasi-judicial action or administrative adjudicatory action, right? Okay, so very simple. Thirdly, we have simply administrative action. So all those actions you can see that these administrative bodies exercise, that is simple, that is the main role of administrative bodies, you can say that. And the last one, we have ministerial action. Okay, what does it mean? It is something like the core responsibility or action or act or function of administrative body. Okay, so that is something like main work, okay, main function. Anyway, though we have understood all these four in brief, but let's discuss each one of them. So starting with the administrative legislative action, what does it mean? When an administrative body makes the rules and regulations, which is in fact delegated to it by the legislature itself, then such rule making action of an administrative body is known as administrative legislative action. We have understood the meaning of delegated legislation. Okay, nevertheless we will discuss it again, but that is something like given to the administrative body by supreme authority. And who is the supreme authority in that case? It is of course the parliament. Okay, so if parliament giving certain power to any of the administrative body, say to income tax department, to revenue department, to make certain rules, regulations, bylaws, so that is known as delegated legislation. Okay, so the legislative functions of the executive consist of making rules and regulations, especially for the smooth functioning of the respective department in totality. Okay, such rules and regulations sometimes also known as bylaws. Okay, since such power is given to all the administrative bodies by the legislature itself, therefore it is also known as delegated legislation or subordinate legislation. Okay, however, here I would also like to utter one of the explanations that is given in your book. That is, to put it simply, when legislation proceeds from an authority other than the supreme authority and is dependent for its continued existence as well as the validity on the supreme authority, it is called delegated legislation or subordinate legislation. We have already understood the meaning of delegated legislation, so don't get mesmerized with this complicated definition. This is simple. We have already discussed the things. Nevertheless, I explained it for your understanding purpose. Further, it says it is a natural companion of intensive form of governance, meaning that when a governance setup is so spread out that it is not possible for the top legislative authority to directly reach out grassroots on its own strength, it can be legitimately expected that rule making would vest in the appropriate and corresponding administrative authority. What does it mean? That if something, see, authority, like if talking about the parliament, it has already so many sorts of works, right? But in that case, it is not possible to make each and every provisions of all these departments. Okay, so what it does, it gives the power, delegates its power to that respective department, and that is the sole purpose of delegation. You can understand that. So this sentence is saying that simply. Okay, so in that case, the power of making rule is transferred to these administrative bodies respectively. Moreover, crisis, emergency legislation is also possible in such a situation. Okay, however, it must be remembered that no delegation must be unfettered, as no democratic society can ever afford an unaccountable authority to govern against the popular will of the people. What does it mean? That though the power has been given to make the rule, provisions, bylaws, but it shouldn't be unfettered. What does it mean? That if you have been given certain power, it doesn't mean that you can make any rule, any provision. Not at all. Your every act will be under supervision. Keep in mind. That will be reviewed. Okay, so whatever you are making, that has to be in the given framework. है ना? So if it won't be, then that will be repealed, removed, or you need to correct that. So the power is of course given, but that is limited. Hence, delegation of law-making power to the administrative authorities, as has been shown in a welfare state, is often controlled. Okay? In view of our written constitution, such delegation cannot be unlimited and must always conform. It's not confirm, rather conform to the basic features of the constitution, as well as the ambit which is given for the delegation by the corresponding legislation. Okay, so conform means following the rule, regulation, right, that is already mentioned by the constitution or in the constitution. So all these administrative bodies, while exercising its power of making the rules, regulations, bylaws, they have to follow the guidelines. Okay, that is the meaning of conform. It shouldn't be arbitrary, right? Okay, moreover, essential legislative functions cannot be delegated. Okay, so you can see that many of the bills and all the things, such kind of thing is exercised by the parliament itself. That functions are not being delegated, right? Now, the next subtopic that we have already discussed above, that is the types of administrative action, namely quasi-judicial action or administrative adjudicatory action. So what does it mean? Along with the regular administrative actions, administrative bodies have also been given adjudicating power to decide and protect the legal rights and interests of the individuals. Okay, for example, the district magistrate, that is an IS officer, more often hear the cases related to property dispute, loan issues, or bankruptcy cases. You know, have you heard ever about the court of collector or DM? Because these guys also exercise the dispute resolution service, okay, and attempt to resolve such dispute. However, such court run by an IS officer, especially a district magistrate, is not the ultimate destination. The decision awarded in this court can be challenged in regular court anytime, as you know that. Okay, so that is the kind of thing as we will discuss in next chapter, that is especially natural justice. In order to ensure the natural justice, this is required, and you can link one topic with other like this. Anyway, so besides, there are separate and well-defined administrative tribunals to deal such cases. Okay, interestingly, the administrative tribunals are the constitutional bodies, as constitution defines its constitution, powers and functions. So this is about the quasi-judicial action of an administrative body. Okay. The next one is simply administrative action. What does it mean simply? Administrative action, which could be either delegated or subdelegated, is the decision-making power of an administrative body regarding formulation and execution of any plan and policies. That is simply administrative action. Okay. For example, the issue of a development of a backward area where there is no road, no school, no hospital, etc. Under the administrative action, the plan will be prepared and executed to provide the basic facilities to such area, to the people living in such area, that ultimately will lead to development of that region. Okay, so such kind of thing is kept under the category of simply administrative action. Now the last one is ministerial action. So what does it mean? Ministerial action or function is the core function of an administrative body, which is given to respective administrative authority by the law, devoid of any discretion or judgment. Okay, it means every administrative body has certain core and defined functions for which its officials have no choice. See, focus on this sentence. For which officials have no choice means they have to do that. No freedom to escape or delay, rather have to exercise those functions. For example, collection of the revenue or tax by the revenue officers. So they don't have any choice other than to collect the tax. That is known as ministerial action. Likewise, this is all about the types of administrative actions, okay, under which we have discussed the 4 types of administrative actions, starting with the administrative legislative action. Then we have discussed quasi-judicial action or administrative adjudicatory action, and then we have discussed simply administrative action, and lastly we have discussed ministerial action. Okay, so this is all. See you in next video with new topic.